pleasure and honor too to present Diana Sancho. Diana holds degrees in law from the University Complutense of Madrid and from the London School of Economics. She is currently lecturer in international commercial law at the University of Leicester, where she was appointed in 2013. From 2001 to 2012, she was associate professor of private international law at the University Rey Juan Carlos of Madrid. Diana, a great pleasure to can hear you.
Thank you very much, Pedro. I would like to thank the organizers for inviting me here. I'm pleased to be here today. My presentation, so it's my turn now, and my presentation is on automated decision making and data protection law, right? And I'm going to look at Article 22 of the GDPR, which is the General Data Protection Regulation, right? So it all sounds very obscure, so I think I should give like a introduction of what is this about, right? This is about ADM. ADM is automated decision making, right? And the terminology is pretty obscure, but it's pretty simple. It refers to a situation where a machine, right, rather than a person, makes a decision on consumers, on us, based on a private information that is online, right? This is what it's all about. This is called automated decision making, right? And this is becoming increasingly common in these days, right? So more and more governments and companies rely on this type of software to make decisions that are automated, which means a computer, based on your data, decides things on you, right? Because of my background, which is more commercial law, I'm going to look at how ADM, this type of software operates in the commercial sector, right? Because the dynamics for when we deal with ADM and governments, the dynamics are completely different. So I focus because of my profile on commercial law. For example, sectors in which ADM is more and more common are basically three. Consumers' loans, for example, when a consumer online applies for a loan or goes to the bank to apply for a loan, and then there is a machine, right, that says this person lives here and likes this and eats vegetables and whatever, and combines all the things and say, yeah, this person is going to repay the loan, so we give this person a loan. Or the opposite, someone applies and say, oh, the machine doesn't like this person, is unlikely to repay, so we don't give the loan, or we give the loan under such harsh conditions that that person is basically not given a loan, right? So we have this sector which is very common. The insurance sector is also a sector which ADM is pretty common these days. And also we have the sector of recruitment. This is as well, if you have applied online for a job or for a position, there's increasingly common software for e-recruitment that thinks of who you are, your profile online, and then makes a decision on whether you are getting a job, you are offered an interview, or you are getting this promotion, etc., right? So again, I'm focusing on the commercial sector. These are the three main sectors or aspects these days. It would expand, but at the moment, these are the most important ones, right? So this is ADM. When a machine makes a decision on a consumer based on the information that is online, right? And then we have Article 22 of the GDPR, right? The General Data Protection Regulation, as most of you probably know, is a very important text that was adopted in 2018 and substitutes all Data Protection Directive 46/95, right, which was the first important text in data protection in Europe, right? So Article 22 is the legal response that the European regulator has provided for this, for ADM. So we have ADM, all these machines making decisions on us, and then we have Article 22, which is the legal response, saying, okay, let's ensure a certain level of protection. So the first thing I would like to mention about Article 22 is that it's not new, right? Because the Data Protection Directive already regulated that in Article 15. However, Article 22 modernizes Article 15, right? So it's a much more sophisticated provision, Article 22, right? It was modernized because the way it was regulating Data Protection Directive was not enough developed to deal with this, with the current increasingly use of this type of software, right? The second thing I would like to mention is what are the interests at stake, what are the conflicting interests that this provision is trying to balance. So there are two main interests to look at here, right? These are the two interests at stake. One is this provision is trying to help to protect consumers, to protect the privacy of consumers, right? So that this is often referred to in the, in the media, like we need to empower consumers' privacy, right? That's the purpose of Article 22, right? To help consumers control how their personal information is processed online, right? The second aspect that this provision tries to balance out is that it needs to as well to respond to the technology and innovation demands of the digital economy, right? Because this type of software is increasingly common because it saves cost and it has a number of benefits, right? So these are the two interests that has to be balanced out. So now, my presentation. I'm going to look at, and that's my paper basically, how Article 22, this provision, contributes to deliver digital justice from procedural, from a substantial, and from a technical level. And these are going to constitute the three main parts of my presentation, right? This is what I'm trying to measure here. Before doing that, we need to look at, because of the terminology and the technicalities of this topic, I need to explain a couple of things before we go through the three main parts of my presentation. So we know what ADM is. It's when when you have an automated decision made based on your information, right? This is ADM, but we need to know how it works. So ADM, this software, uses machine learning algorithms, and it uses these algorithms to profile individuals, right? Machine learning algorithms are a subtype of artificial intelligence algorithms, right? And basically what they do is these algorithms, they go through a large amount of data to find patterns and correlations in order to make predictions on individuals, right? So the computer knows that you like running or you like this sport, and then it sends you ads, or it sends you things that it wants to offer or it wants you to buy, right? So it wants to predict what you want, whether you're going to repay your loan, how you're going to perform at work, etc. It's important to distinguish. There are two main types of algorithms, right? There are traditional algorithms and there are machine learning algorithms, right? Traditional algorithms are rule-based. So this means that there is a human programmer, right, which tells the machine what to do, sets out the rules, says, first do this, after do that, after do that, after do that, right? So some mathematicians say that traditional algorithms are like a cooking recipe, right? Get the eggs and then get the flour and mix up, stir, etc., right? They can be very complex, but a feature that these algorithms have is that the logic behind them can always be understood by a human brain. So a person can always look at, a technician can always look at, say, that's the way the machine is doing, right? They can be very long, very complex, but it's always a person can always understand the logic behind them, right? Even if they are very complex. Machine learning algorithms are different, right? The human programmer doesn't set up the rules, doesn't tell the machine what to do. In a way, they're like an European directive, if you want, I would say, in the sense that the programmer tells the machine what is the outcome, right? And leaves the machine space and freedom for the machine to find out the solution, right? So what it does, it feeds the machine with a lot of data. This is called training the algorithm, and then provides a reward when the machine does well. So mathematicians, they say, machine learning algorithms are like training a dog, right? If you have to train your dog, right? If you want your dog to bring your slippers, your zapatillas, in the morning, right? So you don't sit down with the dog and discuss, you have to go first and take my slippers and then bring them back. You don't do that. You reward the dog when the dog does well, and you leave the dog find out how to get there, right? So the problem, machine learning algorithms can be very efficient, right? And very effective in doing things that traditional algorithms can't do. But the problem they have is that if you leave the machine freedom to find out the solution to a problem, the route it takes makes no sense for a human person, because the way the human brain works is different from the way these machine learning algorithms operate, right? So these type of algorithms that have a problem of opacity. Sometimes they are not transparent. It's difficult to explain how they do something, right? So we can see the benefits of this, right? These algorithms can be very effective. It is beyond dispute that this type of software and technology improves the allocation of services, right? This is one of the benefits. Other benefits this technology has is that it helps to provide a more personalized service or more personalized goods and services to people, right? But on the bad side is we can see that an irresponsible use of this type of software, of algorithms, is a source of unfair discrimination, right? Because they can say, no, we don't like where you live, and then that you eat this type of food, so it means you are not going to repay, right? It can be a source of unfair discrimination, loss of reputation, and financial loss, right? So, Article 22 is the response to this, right? It's the legal regime that has been created by the European legislator to protect individuals and at the same time to let the industry develop, right? Article 22 is a very obscure provision, right? So actually when I first looked at this provision to write my paper, I couldn't understand, I was in trouble because I have to write something on this and I don't even understand what it's saying, right? The language is very complex and it uses negative statements, lots of them. So I'm not going to read this out, but just I want to bring your attention. Look at paragraph number 1, right? It has a negative statement, right? The data subject shall have the right not to be subject to a decision, blah, 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 right? And then look at paragraph 2. Paragraph 1 shall not apply if the decision, blah, blah, blah. And then look at paragraph 4. Decision referred to paragraph 2 shall not be based, so the language is not, it could be easier, it could be more easily understood by a person, right? It's not very good to use negative statements in a provision that deals with rights, right? So, unsurprisingly, I have just added the Spanish version of the article, which produces the same feeling when you read it, right? You have the 4 article with all these negative statements, which means if these are your rights, it's easy to understand what this provision is. It makes the provision very obscure, right? So now, let's look at this. So if I summarize what this provision says, I would mention 3 main things, right? To summarize Article 22, to understand what the content of this provision. First, it applies to automated decisions, right? And specifically, it only applies to automated decisions, which are decisions made by a machine using our personal information that is online, if 2 conditions are met, right? First, it only applies to solely automated decisions. And here the key word is solely, which means it applies to decisions that are made by a machine. If you have a human agent who participates in the decision, Article 22 doesn't apply, right? So this is the first thing to understand. It's it only applies, exclusively applies to automated decisions. The second thing is that it doesn't apply to all decisions. It only applies to automated decisions that have legal effects or have a significant effect on the data subject, right? So it means it doesn't apply to trivial decisions. For example, if you apply for a loan, which is the example I'm using throughout, and you are not giving the loan, right? The machine says, no, because you live here or your income is that, we don't give you the loan. Article 22 would apply, right? But if you open your computer, right, and you browse the internet, and then the computer knows you are looking at the internet and serves you with targeted advertising, right, saying buy this, buy that, that, even if it's an automated decision, would not qualify for the protection under Article 22 because an ad inviting you to buy a product doesn't have significant effects on your life, right? So if Article 22 applies, Article 22 is a protective regime. It's very strict. It's very strict. So when we're dealing with automated decisions, ADM is only lawful under 3 circumstances. If the data subject has consented to this, if it's required to perform a contract, this is called contractual necessity, or if it's authorized by law. These are the only 3 cases in which ADM is lawful in Europe, right? That's why I'm saying this is a protective regime, because it's pretty strict. And finally, the third thing I would mention about this provision is the rights. If a controller is the name of the person who decides why your data are processed, right? If a controller, which is the company which is engaging in automated decision making and uses this type of software, like these safeguards have to be given to you, right? So the data subject has 4 rights. It has the right to human intervention. It has the right to express its views, the views on the decision, and it has the right to contest the decision, right? And there is a right to explanation as well. So summarizing, you apply, using our example, you apply for a loan, right? A machine says, no, I'm sorry, you are not giving the loan because we think you are not going to repay the money. And then you have the right to complain, say, no, I want another decision, and I want a person, a human, be involved in making this decision because I don't agree with this outcome, right? So, summary, this would summarize this scheme here would summarize what I'm saying. So Article 22 is restrictive, it only applies to automated decision, and is a protective regime, right? So now, I'm in a position to start the presentation. This was the introduction. So how Article 22 contributes to deliver digital justice from a procedural point of view, right? And here we need to look at the life cycle of data, of personal information. How is it perceived? Personal information is first collected, right? So these days, your personal data are there on the internet. It's not, so in old days, collection was basically when you fill in a form and you give your data to someone else for that person to process your data, right? This has gone. These days, your data are collected from a variety of sources, like from your mobile phone, from the apps, from your body, which is biometric data, from the Internet of Things, right? From very soon from your clothing or from your fridge, right? So there's a variety of ways in which your data are collected. After that, your data are analyzed. This is where all the companies, the data brokers, you may have heard of this expression, data brokers, this is where they operate. So all these data that are available online are collected and are analyzed and combined and new information is created. This is where machine learning algorithms are used at the analysis process, at the analysis stage, right? And then there is the application stage. right? This is when the algorithm makes the decision, when the machine says, no, you are not giving the loan because we don't like you, or we don't like where you have born, or you don't like your school, or where you studied, right? Article 22, the protection that Article 22 provides, applies at the last stage of processing, at the application stage, right? It doesn't apply before, it only applies there. So the first thing I would mention from a procedural point of view is that the procedural design of Article 22 is based on the idea of single and static processing, and this can be criticized because ADM is a dynamic process, so it's sometimes the analysis and the application occurs in real time, and it's difficult to see where you are, right? But this is a problem generally. I mean, the alternative is not this. I'm criticizing this, but the truth is that it's not very easy to see what the alternative would be, because the law, what we do as lawyers is we classify, we have a reality, and what we do is we do taxonomy, like we classify things so that we can attach rights to different stages, right? The second point I would mention, which is very important, is that from a procedural point of view, Article 22 is too obscure. I mean, the average data subject, the average consumer has no idea what is this about. It's all too obscure, right? So something should be made to improve the awareness of people, so people understand what is this. Because it's not that difficult, it's just a problem of terminology, and it's all too new. The European Union Agency for Fundamental Rights conducted recently a survey on the access to data protection remedies by consumers in the EU, and concluded that almost there were not existent cases on relying on this provision, right? Because people don't know this provision very much. And this is a point, I believe, for the future this should be improved, right? You know, some awareness campaigns should be raised here to improve consumers' understanding of this. So this would be as to the procedural aspect of this provision. Let's look at how Article 22 delivers justice from a substantial point of view. And here we can do a big tick, right? Because this provision represents an improvement compared to Article 15 of the Data Protection Directive. That's very clear, right? So it provides a higher level of detail and is more precise than Article 15, right? Article 29, so the group of experts in Article 29, which is a group of experts in data protection law in Europe, has interpreted this provision, contributing to clarify further the substantial part of this provision, right? So we have a clear definition of what is a machine-based decision, which is a solely automated decision, right? We have limited grounds of processing. As I mentioned before, there are only 3. Companies can only engage in this type of software if it comes with consumers' consent, is necessary to perform a contract, or is authorized by law. So it's pretty tight and defined. And very important, special safeguards for vulnerable adults and children are going to be adopted, right? Which means this gives this regime a higher level of sophistication compared to Article 15, because this suggests that it's going to be a general regime on ADM for general consumers, and then a kind of specialized regime for vulnerable adults, like, for example, ludopaths, or people with some kind of, you know, with has kind of some time of, who put themselves in a more vulnerable position in terms of making decisions online, and children. So if I summarize this slide, substantially big tick, Article 22 is more detailed and more precise than Article 22 is more detailed than Article 15 of the Data Protection Directive. The technical dimension, finally, right? Okay, before I mentioned, when we were discussing the substantial rights of consumers, that a consumer has the right, when he serves an automated decision, say, you are only given this, you know, we insure, you know, you are giving this insurance, the insurance policy is that the premium you have to repay is this one, right? If the consumer doesn't agree, the consumer has the right to contest the decision, right? To express the views, saying, I don't like this, I don't know how you have made this decision, I want a new decision made by a person, because I don't think a machine can make a good decision on me, right? It doesn't understand my circumstances. So this is a very important right that is given to people, right? But obviously it's linked to a right to explanation, because how someone is going to contest a decision saying, I don't agree because of that, if it doesn't understand how the machine, the algorithms, has made the decision on him or her, right? So it's linked to the right of explanation. And this is where it becomes tricky here. Article 13 and 15 of the GDPR says that the controller has to provide the data subject with meaningful information about the logic involved, which is basically has to provide a simple explanation on how the algorithm works, right? So it uses trees, it uses this way of deciding, right? But this is going to be always very limited, the information it provides under this ground, because algorithms are subject to intellectual property rights. So it's protected. You cannot just disclose how it works, right? This is protected by intellectual property, right? But a kind of general information can always be provided on how the algorithm has made a decision. The second limb here is just the controller, and this is where the controversy lies, is the controller has to inform the data subject on the significance and envisaged consequences of the automatic processing. Notice that this provision doesn't say the controller has to explain the data subject the decision that has been made. It says the controller has to inform the consumer about how the processing works, not how the decision has been made, right? And this has created a major controversy in the literature, because some said that if you explain someone how a system makes a decision, so this is called the system functionality, so how a system decides, this is not as good as telling the subject that how a decision has been made on them, right? Whereas other people say the opposite. They say, no, that's a false problem, because if you provide good information of how the system functionality is, so how a system makes a decision, the person can figure out how the specific decision on them has been made, right? The Article 29 Working Party, which is this group of experts on data protection law, has clarified that, has taken a purposive approach on this controversy, has said that what is important is the data subject is provided with enough information to understand how a decision has been made on him or her and why a decision has been made on him or her, because the purpose is to challenge the decision, to contest the decision. So enough information has to be provided for that person be able to challenge in a meaningful way, in an effective way, how a decision has been made. Okay. So let's put it all together, right? The way forward. What can we say? Article 22, we can safely say, is a step in the right direction, right? Substantially, in particular, it provides the individual with higher level of protection, right? It makes very clear which grounds of processing are offered, right? And it makes very clear what are the rights of the data subject. So substantially, yes, is an improvement. But this provision is still in its infancy, right? Because as we have seen procedurally, which it means how you can activate the rights, visibility has to be improved. I mean, the average data subject has no idea what is this, right? And if that person go and read Article 22, is not going to understand. It's too complex. The language has to improve. It should be banned, the negative statements in the law, because they are too complex, right? I believe there's a way of saying things in an easier way. However, to be fair, this is not always, I mean, when you draft, for regulators, when they have to draft law, there is always a political element, and lots of parties have to agree. So at the end, it's a language problem rather than a content problem, right? So whatever, the visibility of Article 22 has to be improved. This is what I would support. And from a technical point of view, more has to be done, because before I introduced very briefly of how the rights of a consumer, right? So when you observe a decision that is unfair, for example, you think it's unfair, you have the right to contest the decision. You have the right to say, explain to me why you have decided this on me, and I don't agree, I want a person making this decision, right? If we look at how this is organized, we have only two people, it's privatized. So it's the consumer who requests information to a controller, the company, who provides the information. So it's privatized, it's between two private parties, right? Some people, and I would agree, say that it should be a third party, which is an agency which controls, a technical agency, could be the National Authority for Data Protection, in Spain the Agencia Española de Protección de Datos, right? A third constituency, someone who checks the quality of the algorithm, right? This is called transparency and accountability of algorithms, right? So we need someone in this private discussion between two parties, we need someone that checks and tests randomly the quality of algorithms, because algorithms are there, they are software, they are created, and no one is really testing them. They could be biased, and then you are only left with individuals to claim that they want a new decision, right? So it looks like the future looks at that. I mean, there are currently some discussions looking at, this is called ethics in algorithm decision making, right? There are some groups that are thinking of which could be like which authority could have these, with mechanisms to improve the accountability of algorithms, but through a kind of specialized agency. To finish, I'm going just to briefly look at the Spanish practice, right? What do we have in Spain? So how Article 22 has impacted on Spain, on the Spanish legal system. So to the best of my knowledge, when I was looking at this, I only found 3 resoluciones from the national authority, the Agencia Española de Protección de Datos, looking at ADM rights, right? Of these 3 resoluciones, the two of them were not really dealing with ADM. They were dealing with the right of access, which is something different, right? So only one was dealing with that and was discussing the definition of ADM. So the first thing to comment is not much practice. The new Spanish Data Protection Act, which has been adopted in 2018, has Article 18 refers to Article 22. So this is an improvement. So we have a reference. So Article 22 has been properly referred to in Article 18 of the Spanish Data Protection Act. If I want to be pedantic, I would say this could be improved because Article 18, right, of the Spanish Data Protection Act, the title is Derecho de Oposición, the right to contest. And within that, 2 rights are looked at. Within that, we have this provision encompasses 2 different rights. The right to contest, which is one right, and the ADM rights in Article 22, which is a different type of right. So it would have been better to have Article 19 on ADM rights separate from Article 18 on the right to contest, right, which are separate rights. But whatever, I mean, this is just a comment. The truth is just is a proper, it's clear. If you read the article, it's clear, but it could be improved. Certainly, Article 18 represents an improvement compared to the situation before Article 13 of the old Spanish Data Protection Act. Article 13 of the previous Data Protection Act, the Ley Orgánica del Poder Judicial of 1999, transposed Article 15 of the Data Protection Directive, but it didn't transpose this provision in a very accurate manner, right? The transposition was not very good. And because of that, the provision lacked legal certainty, so the scope of application of the provision was different from what Article 15 intended to on the directive, right? That's why the solution of the regulator, the Spanish regulation, was to adopt Article 36 of the Data Protection Act regulations, the reglamento, which was a perfect transposition of Article 15. So the outcome was all right. The outcome was all right, because at the end, Article 15 of the Data Protection Act was fully transposed in Spain. But the legal technique was not right. You cannot have the act that has an incorrect transposition and this to be suddenly corrected with the regulation. And that's all. That's the end of my presentation. I hope you have enjoyed, and I'm happy to take any questions you may have. Thank you very much.
Thank you very much, Diana. I'm going to resume your presentation. This presentation has discussed the European regime for automated decision under Article 22, the General Data Protection Regulation. Giving machines the task to make decisions on individuals is becoming increasingly common. More and more governments and companies rely on artificial intelligence algorithms to make decisions on individuals. As Diana has discussed, this comes with some benefits, but with some risks as well. An irresponsible use of these algorithms may be a source of unfair discrimination. Diana's paper has analyzed how Article 22 GDPR contributes to deliver digital justice from 3 points of view: procedurally, substantially, and technically. She has concluded that Article 22 represents an improvement, though the legal regime needs to be further developed. So, it's the time to the questions. Any questions? I understand that this time is very hard to all of us, but okay, Professor Luis Arroyo and then Professor Adam Sigan.
I will not refuse the opportunity to say something about this, because about 1 month ago, I think that we created a network of experts on artificial intelligence and administrative law specifically. And of course, all these topics, all these ideas about Article 22 of the regulation are of crucial importance. And the point I want to make is that actually all these rights are pretty familiar to administrative law specialists, because apparently what we are looking at here is an excerpt of a syllabus of administrative law course. I mean, we're speaking about the right to be clear, we're speaking about the right to get a reasoned decision, we are speaking about the right to contest, right, to challenge somehow, somehow I should have a right to an effective appeal or contest. A right to get information about what is going on in the decision-making process, who is behind the machine, how the machine is supposed to work, how this decision shall affect me. So all these are guarantees of administrative law. Of course, guarantees which were originally designed thinking in decisions made by public bodies. And the point I want to make or to stress is that all these guarantees are now being applied to not only public bodies, but also to private institutions. Because the idea that lies behind is that, well, as long as those institutions are taking important decisions that affect me, and in this respect they are exercising power, then they will be subject to this catalog of rights or of limitations. No matter of this power being public or private, no matter we are facing a negative decision of the application of a loan granted by a financial entity, or we are speaking about Uber calculating the rate that it is going to apply to a trip that we are that we have in mind to do, or if we are within the limits of the state, of the public power, for example, in terms of dealing with applications of social aids, or in terms of domestic violence claims, which is another area in which these kind of algorithms are presently used in Spain and worldwide. So that was my comment. How public law original guarantees are being exported, are being applied to other areas.
Thank you very much for your comment. I would completely agree. What I look at this, the way I see my research is just like a drop in the ocean, right? Because the way I approach this is from a commercial law perspective. So how data protection law as a public regulation changes or modifies the behavior, the conduct of private operators, right? So like consumers and companies. This is the focus of my research, right? But as I go through this, sometimes it drives me crazy that I don't know where I am, because the thing is, this blurs the limit between public and it completely. So the main instruments we have from a commercial perspective to look at this is just contract law, to see how the people, the companies, how the schemes they use are based on contract law, or is tort law, when someone feels that is unfairly treated and brings a claim for compensation, like in compensation now is, for example, in the UK you have the very important case Google and Vidal, right, which says yes, you have the right to use tort law for this. And so you have contract law, you have tort law, you have property law, because there are like some ways saying that let's make private information, let's treat this as property rights, like as if they were IP rights, right? There's this trend. So you have this, but the more you look at that, it's just you don't know where you are. So the thing that it challenges, it blurs the limits of what the normal thing of the public and the public and the private divide is, and this is just the beginning, right? So the revolution to making law in the law treatment of that is how you become used to kind of merge the different approaches to kind of a cross-sectoral approach to deal with that, because as it develops, you can see the limits of just focusing on one methodology to look at the interests at stake. So I would support that, this idea of where we are, that is the blurring of the public and the private divide.
Yeah. I was really interested, I think it was on the previous slide, the point that you make in very.
What?
Yeah, that's the yes. I was interested in the point that you make about protection at the technical level. So I think that raises a number of very important issues. Predominantly around, firstly, if you want access to justice, then the citizens need to understand what the nature of this law is. And I think you're absolutely right. It's a very technical piece of legislation, and it's not that accessible. I also think the point I think you just made about Uber is a really interesting one as well, which we sort of came to mind, in that what is it that citizens are concerned about? Because if you are hailing a cab through Uber, it's a technical solution which makes your life easier. You're not necessarily going to be concerned about the ramifications for your data afterwards. You want your taxi to turn up quickly, and you want to get to your destination. And I think that's, again, something where there's a gap between what citizens can see and what the purpose of the legislation is. But I'm interested in the way you pitch that about protection at the technical level. Why do we say it's accountability versus transparency rather than both? Because I would see both being very closely interrelated between each other. And that's the bit that I couldn't understand.
Well, that's a very clever point, Adam. Under the Data Protection Directive, because it was kind of a second generation document on this, the whole focus was on transparency. There was no such a thing as a principle of accountability as it is now, right? So the data protection framework was based on transparency. It's everything about introducing the idea that companies and government have to be transparent. But this transparency is not enough to deal with this, with the digital economy, or this is what at the European level, that is the construction. They said the GDPR has introduced the principle of accountability. So there is a provision, Article 5(2) of the GDPR, that says everything we are setting in this, all the duties in this regulation, right? There is an obligation for controllers and government, anyone who deals for controllers, anyone who deals with data, there is an obligation for them to be accountable. They are accountable for what they do, right? So this was the kind of the industry responds to say, okay, transparency is not enough, so transparency plus accountability, right? The industry is very happy with accountability because that's what they used to say, we don't need any further regulation because we are very responsible. Our work is based on ethics and we are accountable, so we don't need any further regulation. That's why sometimes this debate is presented in terms of kind of transparency versus accountability, but it's not against. They should work together. And what I would say is that ethics is not enough in law. I mean, ethics is very good, but it's not enough. You need the law to enforce ethics, right? Because it's not enough accountability. So, and I think that at the technical level, this is privatized. So it's just the consumer say, I don't understand this decision, why am I excluded? And then the controller will say, okay, read this form, read this email. We have done this decision because of this algorithm, and then you blah, 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 and that's the decision, right? This is privatized. So we need, it's like the same, it's like the new idea of, it's like tax law authorities, right? Tax law exists, there is an authority, and they do random checks on who is compliant, right? This is the same idea which is taken from tax law, which is put there saying we need, if algorithm decision making is going to be in the future the rule rather than the exception, we need like a body that, we need a specialized body, so it's not privatized, it's not between two individuals who just try to meet their expectations and their rights, right, or their interests. It's just kind of it reaches a higher level where someone is ensuring at a technical level that the algorithm is not a biased algorithm, right? And this is the idea that more and more is, despite the industry, which is not very happy at that, because it would be like another control, it would be for them another cost, but this is very much the idea that is, as far as to the best of my knowledge, that is being discussed at the moment.
But I think what that does raise, though, is that you also then have to convince consumers that technical developments are not necessarily always to their advantage. I go back to the point that you say about Uber. Yes, you can order your taxi if it's there efficiently, but what's the consequence of them holding that data with respect to that? And I think there's a massive gap between what the citizen understands, is simply being given a big sheet of paper or having the terms read out to them, and the consequence of that data being held and potentially sold on and misused and abused. I mean, there's a gap there that the legislation doesn't seem to fill.
Absolutely, that's the technical word for that is called the privacy paradox, which all of us we click because what we want is we want the service we are looking for, and we click. We don't care about what happens in the future, right? But then we don't care about the big data industry. It has a technical name and it drives the authority crazy. And the only way to tackle this would be like education campaigns and awareness, and also having more bodies involved in the accountability of this. It cannot be. The industry, recently I attended in London a meeting with people from the industry, they were all ethics this, ethics that, and it's not enough, at this level of complexity. That's what I would say, yes.
Thank you very much. It's very enlightening paper, which is one more example, I guess, for the limits of the public-private divide. I completely agree with this before. And I have a question, which is a real question. It's not a rhetoric one, it's just that I don't have an answer for that. I am concerned that you are lawyers about access to justice. Then, about control in general. We're talking about this general controller which should be set. Who is going to compose that controller? What kind of people are going, or do you think should control this type of things, of realities? And indeed, this is a real question. Maybe not everyone. Are judges prepared to control this type of realities? And I was thinking now about the conference we had several months ago of the Association of Professors of Administrative Law, where there was one very interesting paper on the limits of the jurisdiction as it is now concerning this type of decisions. Not only these ones, but others as well. One of the proposals, which didn't provoke very much debate, because actually there was not much debate in general, was whether judges, namely maybe computer engineers or any other type of technicians, should be part of courts. I mean, not just head courts to their job, but whether they should be part of courts. In the last instance, I guess, whether these type of decisions are going to be controlled from a technical point of view, so from a legal point of view as well, by computer engineers or any other type of technicians. What do you think, given your experience in two jurisdictions, whether you see any difference between both of them?
I mean, it makes complete sense. It makes complete sense what you say. So the regulation of this sector is a challenge because in the sense that it requires lawyers working together with engineers and technicians, right? And at the moment, at the level of remedies of justice, data subjects have like 3 levels, right? So this is would be the first level where you go and you say, hey, this decision, I got you. This decision, I don't like this decision on me, so challenge the decision at the origin, right? It would be the first level of justice, right? If the consumer is not satisfied with the answer that this company is giving to that, provides the decision and the consumer is not satisfied, there's the second layer, he can go to the authority, in Spain, the Agencia Española de Protección de Datos, to the national authority, right? Who has competence to go through and investigate. The person as well can go and bring claims, it has the legal system to bring claims in civil, saying discrimination, compensation. So it has this kind of 3 levels of protection. But specifically for this, as you pointed out very well, very clearly, there is another stage should be added to the equation, which is at the very beginning when the algorithm is created, because the whole thing is about the algorithm, the decision-making process, how you are making a decision, right? So this has to be fair. And this has to be, someone has to control, there's an authority there's a body that has to control the quality of the algorithm. So otherwise you can have anyone, like a supremacist doing algorithm and saying, oh black people, I don't like this, I don't like that, I don't like women. So it's more and more clear that the system that is envisaged or a possible system to deal with that, self-regulation is not enough. Or self-regulation would be enough for some things, but not to control the quality of the algorithm. The more and more they say that there should be like in tax law, right? You have the authority, you have a body, and that's random checks. Like this person, let's see how, like random checks on algorithms that are used, which would be that body would probably have lawyers, engineers, mathematicians, computer programmers all together, finding a way to test, so that they would kind of release the judges or the legal stage later on, which would be then left to check whether the rights have been applied or not, without the technical dimension. That would be a good, I suppose, a good management or a possible way to manage this in the near future.
Okay. Any questions? Considering the time, I think that it's better to end this session, and we see again at 4 o'clock. See you. Bueno, muchas gracias.